is reported the movie theater arrest, which didn't even lead to a conviction. I'd point out that under page 12 of the application, such an arrest which didn't lead to a conviction need not be reported. And so if that doesn't go above and beyond what's called for in terms of being having candor and being forthright with the bar, I would be surprised. I'd also like to note in regard to the bar's position that I somehow inadequately reported the academic dishonesty investigation, that my Exhibit 1, page 25, wherein I have an update to my application, has language in it that is pretty much taken directly from Mr. Philip Burns, the Student Judicial Affairs Officer at UNLV's one page, and I believe this is exhibit that we looked at with Dean Smith, his one-page summation of what his investigation and his ruling says. In that, I quote from Exhibit 1, page 25. After the student this is paragraph 3. After the bottom of it. After the Student Judicial Affairs Officer for my law school conducted a full investigation, the matter was resolved with a finding that no academic dishonesty took place on my part. How Ms. Kagan can try to turn this into I somehow didn't report this or inaccurately reported it when that's language taken directly from Mr. Burns's ruling on the matter, I don't understand. I have 1 second to get my index, Your Honor. Sure. For the one other thing, and I'm just trying to stick to things that really stand out to me and not take up any more of your time with things that I don't have a good faith belief are important to this case, is the lab program. And I don't know if you've ever seen a lab program brochure like those that are out in the hallway before your courtroom. They go to great lengths to stress how confidential the program is. And I would say that I have trouble understanding how this program is at all confidential when I entered abeyance agreement with the State Bar, which called for, and I'll quote verbatim, the lab program to monitor my recovery from alcohol abuse.
What is Mr. Coughlin quoting verbatim from?
1 second, please. That would be the abeyance agreement between myself and the State Bar, dated July of 2004. That would be exhibit number 38, I believe. Wherein on page 2, paragraph 3 rather, it says Coughlin's recovery from alcohol abuse will be monitored by an agent from the LAP program. I don't understand, one, how a program that so openly purports to be confidential and stresses that in all its literature and advertisements and bar journals and the like, can result in someone like myself having all their medical records gone through.
Didn't you sign a waiver of confidentiality and
But-
release of information?
Well, that's what I'm getting at. Is this just the biggest catch-22 in the world? We're going to say, we're such a confidential program. Now sign this waiver releasing your confidentiality. They do that.
Happened in this case, okay?
They
So
do
let's
that to
move on to
everybody.
another issue, okay?
Every single applicant. So why say you're a confidential program? I don't
Mr.
get it.
Coughlin, you waived it, move on.
I don't get, in my narrative
Understand
testimony,
you
I'll
don't
say,
get it.
I don't
Okay.
get it.
You obviously don't, so let's go on.
No, I really don't get it.
Okay, that's clear.
Further, this involvement with the LAP program, whereupon I entered into an agreement with the State Bar, which says that my recovery, and I'm quoting from Exhibit 38, page 2, paragraph 3, as I did earlier, my recovery from alcohol abuse will be monitored by an agent from the LAP program. How that can turn into getting all my medical records and presenting them to the bench, how that can turn into having that in an opinion, how that can amount to, if you look at the LAPs, and this goes to something we spoke about in one of our teleconferences, Your Honor, wherein you said,
The issue is whether you have the requisite moral character to become a lawyer in the state of California. Confine your testimony to that issue.
okay, Your Honor, I believe it is, my testimony right now does
A
speak to
waiver
that.
of confidentiality has nothing to do with it.
Does it have to do with one's candor? If one's been battered around and treated like
Protesting the
Sipowicz
fact
on
that you-
NYPD Blue, is one going to be all that candorous? If one has no faith in the people who are,
Okay, come on, let's move on with your testimony.
well, it's, you need to show candor, but is that in a vacuum or does that depend who I'm talking to? If I'm getting abused and having vexatious and nefarious tactics thrown at me, am I still supposed to be
Into the
completely
characterization of
candorous?
that.
Yes,
In the face of all that?
in the face of all
Should
that.
the Duke lacrosse players been completely candorous to the
Actually
runaway
relevant.
rogue prosecutor?
I'm not going to answer any more questions. I am not the person on trial here. You
I'm
are.
testifying. That was more of an extemporaneous
Please
question.
testify.
That was a theoretical question I was
I
including.
understand that. Move on.
Okay.
I'm giving you 15 minutes, and then I'm wrapping this up in terms of your testimony, and you,
So I get 15 minutes, but we can take an hour and a half to verify documents from the DMV
yes,
that prove speeding tickets that didn't even need to be reported.
that's correct.
Okay.
Go ahead.
I just wanted to be sure about that. So I'm still confused as to,
That confusion is not what you're supposed to testify about. Will you just please testify as to rebutting the State Bar's position that you do lack the requisite moral character to be a lawyer in California? That's what you're on trial for.
Yes, Your
That's
Honor.
what you're on the stand for right now. Rebut that evidence.
Okay.
Not tell me you're confused, you don't understand. That is not evidence.
Yes,
Your
Your Honor.
confusion.
I feel that the State Bar's assertions that I don't have this character that they speak of are without merit. Chief among the State Bar's assertions relate to my reporting of academic investigations or something stemming from my time at UNLV, and that would relate to the questions in the application. Exhibit 1, for instance, wherein it calls for reporting any sort of censure or punishment meted out by a school. And I'm saying in my application, not only did I, in my opinion, say everything that had anything to do with that moving a computer issue. I reported I was fined for $100. I reported I moved it. The only real issue we seem to have is how far I moved it. I said 10 feet. The witness says it's in a room that's oblong, that's no larger than this room. So to say I somehow didn't report that, I think is baseless, or that my reporting of it was somehow inaccurate. I don't see where there's an issue with that at all. So that leads to the State Bar saying there's an issue with my reporting of the paper investigation for which Mark Trotta's testimony was to speak to. Well, I direct the Court's attention to Exhibit 1, page 28, wherein page 25, wherein if you consider the last two paragraphs, and this goes to candor and rebutting the State Bar's assertion that I somehow was misleading in my reporting of this. And I know I've already hit on this, but I just want to take 1 second to point this out again, is that I did report there was an investigation, an academic dishonesty investigation, whereupon the State Bar is certainly able to get the story from someone besides me, So largely, just reporting it in itself pretty much, in my opinion, it covers the candor aspect. Now, granted, if someone goes on to tell a bunch of lies about it, then that would prove to be otherwise. But I take language straight out of Mr. Burns's report. And I'd also like to mention that I'm not entirely sure that I didn't provide that report to the State Bar. That is not clear to me, because I believe there's a good chance that I would have provided I or Mr. Fishkin, my prior attorney, would have provided that report to the State Bar.
Objection lacks foundation.
But did you ever prove that I didn't?
I'm going to overrule the objection.
I don't recall it ever being proved how they got a hold of that report, and whether or not it wasn't.
The question is did you give them this report? Did you give them this report?
I'm not sure.
Okay, so let's move on to the next.
Okay, but a characterization. Okay, but clearly, in page 25, I guess you'd call it an addendum or something to my application. I say there's an academic dishonesty investigation. This is this third paragraph. I say the matter was resolved with the finding that no academic dishonesty took place on my part. That's accurate. Dean Smith testified as much. Mr. Burns's opinion letter on this says the same thing. So where the State Bar is saying I was inaccurate or misleading, I'm not sure. I gather it's from the sentence that says there was a formal letter of warning. But I'll note, if we refer to Mr. Burns's
Exhibit 53.
Thank you, Your Honor. If we refer to that, I'll direct you to the last paragraph, whereupon Mr. Burns says, I am recommending this case be resolved on an informal basis. You have 10 working days after receipt of an informal resolution letter to request that a formal hearing take place. All sanctions offered through the informal process will be void. The formal hearing committee, and it goes on. So that language to me certainly sounds like this is informal. Further, in paragraph 2, there's further language that points to an informal tone to this. this whole investigation and the resolution thereof, wherein it quotes in paragraph 2, line 4, in addition, it appears that academic dishonesty did not occur, or I'm sorry, above that. After an investigation, it appears that the matter of your remarks has been informally resolved between you and your instructors. In addition, it appears that academic dishonesty did not occur. So how the State Bar can go on to say, well, I somehow inaccurately reported this such that you should deny me a law license after 5 years of fighting this battle with the State Bar in their deep pockets and extensive set of resources that they have to use in presenting something like 10 witnesses, in having...
Motion to
Coughlin,
strike.
it appears that you are running on, and I think what I need to do is direct your attention to what the court is interested in. I've heard enough information in terms of what you didn't report on your application in terms of the student investigation. Okay? I've heard enough evidence on that. The real issues here are the failure to report the Department of Motor Vehicles violations, that is the failure to appears. There's also the civil judgment and defaults that you didn't report. There's also your employment history, your address history, and your financial obligations that you didn't report. You should direct the remainder of your testimony to dealing with those issues. They were not reported.
Okay.
They were material omissions that were not reported. Deal with that.
Thank you, Your Honor. I appreciate your focusing me in that regard. If I had telephone conversations with Ms. Kagan that would amount to reporting the default judgment, would that be pertinent?
Objection.
You can testify to whatever you want to testify to. All I'm saying is that they're not on your application and they're not written, and you need to provide us with an explanation as to why they weren't on your application, why we were not given an update until a certain point.
Okay. Well,
We're not given an update until 2/15/07.
not a written update until that point.
A written update.
Obviously, the phone call to Ms. Kagan would have taken place prior to that.
That's all hearsay. I don't know. It's inherently unreliable. It's just your verbal assertions. But if that's the evidence you want to present, that's fine.
And can Ms. Kagan be made to speak to that?
No.
So we can't ask her that.
Ms. Kagan is not the Committee of Examiners. You were supposed to report this to the Committee of Examiners. She is not a member of the Committee of Examiners. You need to offer an explanation as to why you did not report these things.
Okay, and that's true even when Ms. Kagan came into the picture?
That's true even when Ms. Kagan came into the picture.
So anything I report to her cannot be said to have been reported to the State Bar? So in essence, if I didn't send my update to the State Bar, I still haven't reported it to them, right, about the financial stuff. And
Mr. Coughlin, please just address the issues. There's nothing until September 15, 2007. Prior to that, it wasn't reported. Why not?
And September 15, 2007 is the update I sent, the 30, 40 pages with the like
February 2007.
the something like 800 AA signatures that show 1 hour meeting each at each signature. Of course, the phone call to Ms. Kagan would have taken place prior to this. I find the fact that Ms. Kagan is not acknowledging, or appears not to be acknowledging this, further
I'm going to
proof.
object on the characterization of this testimony.
Sustain the objection and strike it. You need to deal with why you didn't report this to the bar.
I believe a prosecutor has a duty to report exculpating evidence.
Okay, let me just give you an example. Have you ever been in business for yourself? You reported that you were in business for yourself, October 2003 until 2005. At that time, to my knowledge, Ms. Kagan was not even on the case. Why wasn't it reported in 2003 that you had, in fact, were an owner and operator of your own business when you were supposed to report it? Those are the kind of issues I'm interested in. I'm not interested in a diatribe against the prosecutor. You are the person that is sitting here on trial.
Okay.
So you need to address those issues. I would suggest that you stay away from impugning Ms. Kagan. That is not helping your case.
Okay.
You need to take responsibility for your material admissions from this application.
Okay. Your Honor, I do need to take responsibility for not reporting the debts I owed earlier, for not reporting the business, although I can't say I knew I had to report that. I know there's language that says you have a continuing duty, and if you look at this application, and you read it verbatim, and you continually ask yourself over this 5-year period, do I need to do any of this stuff? Then you might say, well, yeah, I do, because right here in page 30, paragraph 2, sub 1, it says you need to report. But I'm afraid I only reported the things that really I was quite sure needed to be reported. Things like being arrested, things that stood out as having, a salient quality to them within this application. I've seen case law where someone failed to report some minor aspect of something related to a question in this application. However, they reported something more serious, like an arrest, and the court took note of that, and it weighed the relative importance of each reporting, and found something like not reporting a failure to appear that stems from not having proof of registration and paying the fine late as too inconsequential to affect one's the decision of whether or not one should be given a law license after going to law school and passing the bar exam and incurring a great deal of student debt. I mean, as a public policy issue here, I think a certain amount of I don't want to say common sense, but I think a certain amount of that's just too harsh. We're going to turn this guy's law license down because he didn't report he had a speeding ticket. That's a little harsh, I think, and I think that sends a bad message out to people about this profession, and it sends a bad message out to prospective attorneys. So I agree with you. I do need to take responsibility about reporting things like the financial debts, about reporting that I was in business for myself. With regard to the judgment, the civil judgment, or first with regard to the unlawful retainers, I can't say I didn't realize that needed to be reported until some point, probably after Ms. Kagan indicated that to me. I didn't realize that there was case numbers and cases against me. I thought I had been evicted. I didn't realize the implications of that, or that if there was some hearing that took place later, I didn't know about it. And so hopefully that can be seen as somewhat of a mitigating factor in my not reporting it, although certainly I do have a duty to know this application backwards and forwards from what I can tell, and that perhaps I could have somehow known that. But I don't see, I don't know that we've proved that I had knowledge that there was an unlawful tainter action against me. I think we can prove that I've been evicted, but I don't know about, if those are the same thing, maybe they are, but that's a subtle distinction. With regard to the judgment by the unishippers, that to me seems more obvious, that that's something that needs to be reported. However, I can say that at the time that judgment occurred, which my understanding was sometime in either 2005 or early 2006, and just by way of reference, I was terminated from the lab program in early 2006. So whether or not I have a duty to report anything after I've been terminated from the lab program, I don't know. And even prior to that, I don't know that I have a duty to report something. Now, there might be a rule saying just this, but that I have a duty to report something after the state bar has turned me down as well. At that point, as I understand it, I'm involved in a litigation. It's a little bit different than someone who's originally applying for something. And I think it's important to note that in my original application from '02, I don't believe the state bar has shown that there was anything of substance that I failed to include or that I was in somehow misleading about. All the issues the state bar is taking is from events that occurred, some of them in late '05 that weren't reported. And at that stage of the game, I'm in a litigation with the state bar, or earlier than that, I had an attorney, Mr. Fishkin. Mr. Fishkin knew I was running a business. Whether or not reporting that to him is tantamount to reporting to the state bar, I don't know. I certainly didn't tell him not to report that. I would submit to you that I did make mention of my need to report things to Ms. Kagan early on into the start of this litigation, and that Ms. Kagan indicated to me that I would have an opportunity.
Hearsay.
Sustained.
I'm not able to say what she said to me.
Okay, it's not going in for the truth of the matter stated. It's relevant to your state of mind. Okay, I'll let it in.
Okay, thank you, Your Honor. Ms. Kagan said to me that I would have an opportunity to update the state bar with regard to the things that needed to be updated in connection with my application. At some point, Ms. Kagan must have changed her mind because she filed her application, which...
I'm going to object to this testimony. There's no documentation to that effect, and I can't get on the stand and rebut these statements.
It's not going in for the truth of the matter stated. It's relevant to his state of mind and how he... I will go ahead and let him testify.
Thank you, Your Honor. And so if we're talking about not reporting that judgment in connection with the shipping charges, my contention would be that if you could consider my statements to Ms. Kagan as reporting it, which would have been sometime in mid to late '06. And if the judgment didn't come until, I believe, around either late '05 or early '06, then, and in the context of being involved in this litigation, I don't know that there is a duty to report it at that phase. I don't know that I knew there was a duty to report it, or that I remembered that the application had language to the effect that certain things involving administrative hearings or something like that need to be reported. I don't know that. And if indeed I did become aware of a need to do that, or became cognizant that that might be something one needs to report, I can't say that I knew that I wouldn't have an opportunity to appeal that prior to needing to report that, or that I was sure that my appeal avenues had been exhausted in that regard. As far as not reporting stuff, that's pretty much all I wish to say about that. If there's, I can think of some other things I would go on about, but if there's something you could direct my focus to.
No, I think you've covered the issues in terms of what this court needs to know.
Okay, so if I can just be sure, Your Honor, before I, say I don't have anything else I'd like to address.
Discuss the academic dishonesty investigation.
And the reporting there. The reporting is what's really important, isn't it?
Yes. You have reported the law school computer. You have dealt with that issue. Dealt with the employment history in your termination. You've dealt with the U.S. Patent and Trademark Office.
I'm sorry, Your Honor, my termination from where?
Termination from law firms.
Okay.
You've dealt with.
And that's important.
You've dealt with the issue of the U.S. Patent and Trademark Office. You've dealt with the substance abuse issue. You've dealt with the conviction issue. And now You've dealt with the material omissions issue.
The conviction for dry reckless?
Yes.
Okay, and can I move to strike anything in regard to the movie theater arrest?
No?
Okay. Does it matter that those aren't required to be reported by the application?
That issue goes to behavior. That's not to reporting. Okay, and we have dealt with the civil judgments in default, dealt with the address, financial obligations.
Well, I would like to make a few statements about the not reporting of things like the address and
Go ahead.
Okay. I think upon a review of this and the dates of my arrest, you can tell, and in fact, my reporting arrests that didn't even need to be reported to the State Bar, which I did in my original application with regard to the movie theater arrest, but also in my prompt reporting of the DUI, dry reckless conviction arrest, you'll see a trend here, and it's anything that obviously needed to be reported was promptly reported, and I believe yourself, myself, and Ms. Kagan could point to situations where we are vaguely aware, or we might be aware that some prospective attorney didn't report something like a DUI or didn't report this or that and got away with it. And that's not what's going on here. I reported my arrest promptly. I reported the movie theater arrest, which wasn't even required to be reported. Also, I went in and brought up the subject of alcoholism with a committee that has a lab program in its infancy that perhaps hasn't gotten all the kinks out yet. So, to me, there's so much candor going on here to try to say that that's undone by not reporting expired license plate ticket failure to appear doesn't seem right to me. But also, just what I really wanted to get at was, okay, we're saying you're not really keeping us updated in the way we'd like to see an applicant do it. You're not giving us your address history promptly. You're not reporting speeding tickets, although I don't think those are supposed to be reported, but things like that. And I can say, absolutely, I agree with you. I should have done a better job of that. I should have been more fastidious in particular and prompt. And I don't know that, but I don't know that I can communicate to you quite what it's like going through a 5-year thing like this with 3 different state bars. And it's been longer than 5 years because all this, what you see in these exhibits, started to occur in late 01, okay? And so now we're in May of 05 or 07. So, that's something like 6 years and change of going through this. And, that's on top of taking and passing 3 bar exams, getting out of law school, going through law school not on somebody else's dime, but through a great deal of student loans and saving and sacrificing. And so, for a lot of people, that's tiring enough, just doing that. And then starting a job where you get paid a good deal of money is tiring. Well, I didn't do that. I did all that, and then I got 3.5 years of waiting and litigation with the Nevada Bar. I got to go to, and I'm thankful for this now, but I got to go to something like 800 AA meetings. I got to have an extensive involvement with the State Bar, which is culminated in a trial that's going to last at least 4 days, And so, and this is in the context of having documented, established chronic back and neck pain, ADD, and perhaps some other issues that I would ask, if you have the time, please review my doctor's records that are included in these statements. Because I think if I'm going to go to the trouble to pay all these people to make these records on my dime, which if we get into the lapse stuff, will show lapse statement where they say, nobody will be turned away because they can't pay. We'll pay for you if you need help with the lab. That wasn't the case with me, because I wound up paying all these doctors for their reports and a lot of stuff, So my involvement with the lab and the financial difficulties of all this, in combination with some of the physical problems I face on a daily basis, like chronic back and neck pain, ADD, and whatever other issues we want to talk about. And I'm certainly not going to get into alcohol-related things because of the bureaucratic morass that has surrounded any attempt to have an honest discussion about that with the State Bar. But all that in total can wear you down a great deal. And so you may not be on top of your game, and you might not be reporting where I live from when to the State Bar as promptly as you should, But I would just ask that you try to take give that some consideration. And other than that, I don't think I have a great deal to say, other than, I think it's a shame if someone like Judge McGee, a district court judge, doesn't get to have, an opportunity to...
And I'm going to sustain the objection at this point. Do you have any more evidence?
Well, we're still, I had a urine and blood screen taken at this independent medical exam. We're still going to get into all that, right?
With the doctor.
Okay. So no, as of now I don't.
Okay. So you're reserving the rest of your testimony until after the doctor testifies?
Yes, Your Honor.
Okay, thank you. Do you have any cross-examination?
Only the question of whether Mr. Coughlin wants to admit the doctor's report into evidence at this time.
Is that pressing at this point, or can I take some time to review it further?
Sure.
Okay.
Up to you.
If the court doesn't mind, I'd like to have the opportunity to review it further.
Yes.
Certainly if I'm coming back.
So, that's fine. Okay, any other?
No, Your Honor.
Thank you, Your Honor.